Lords, Amendment 143 is intended to provide a tougher remedy for breach of the obligation, which is a very modest one, to consult in cases of collective redundancy. At present, the remedy is an award of loss of earnings capped at a maximum 90 days, which the bill proposes to increase to 180 days. My amendment's not concerned with that. It proposes judicial intervention to prevent the breach, or at least to restore the position prior to the breach. So, where a declaration has been made by an employment tribunal, the union should be entitled to go to the High Court to obtain an order to enforce that declaration. The employment tribunal does not itself have the jurisdiction to make such an order. Indeed, it doesn't have power to enforce its own orders. That's the reason why it's necessary for workers to issue further proceedings in the county court if their employer fails to pay a tribunal award. Lords, the amendment makes clear that any dismissal which should have been subject to Section 188 of the 1992 Act but was not will be void and of no effect. So the obligation to continue to pay wages and to honour the other incidents of employment will continue until the employer has fulfilled its legal duty. I should add, in case any of your lordships doubted it, that the High Court does indeed have the power to restrain dismissal and declare a purported dismissal void and of no effect. The Court has often done so, where the dismissal was unlawful because, in breach of contract, the power is still more apposite, where the unlawfulness is breach of a statutory duty. Finally, the amendment puts beyond doubt that the normal consequences of non-compliance with an order of the High Court will apply, namely that the company and any officer personally frustrating the order may be subject to proceedings for contempt of court, including fines, sequestration and, in the most egregious cases, imprisonment. Lords, the rationale for my amendment is obvious. We're talking about a situation in which an employer has broken or proposes to break the law by throwing a significant number of people out of work without properly consulting on measures which might have avoided that situation. A very limited financial penalty is plainly not enough to dissuade lawbreakers, as I think the noble Lord Hunt recognised. What is required is not just a more dissuasive remedy, but one which prevents the unlawful situation, or at least restores the situation to lawfulness so far as it can be restored. Only the High Court has the power to do that. But there's another reason, and that is the need to comply with the international law which the UK has voluntarily ratified. Conventions 87 and 98 of the International Labour Organisation will need more detailed consideration in later amendments. For current purposes, it's enough to note that together they require member states, not just ratifying states, to respect and protect freedom of association and the right to bargain collectively. Compliance with international law is the eighth of Lord Bingham's principles of the rule of law. The importance of compliance with international law was emphasised by the Attorney General in a speech to the United Services Institute last week. It matters not whether the provision in question relates to trade, the environment, security, labour or any other matter, and compliance is not just restricted to the black letter of the treaty, it's also required of the decisions of the bodies appointed by the treaty to supervise compliance with it. One such constitutional body of the ILO is the Tripartite Committee on Freedom of Association, consisting of representatives of government, employers and workers. On the 8th of November 2023, it published its decision on a complaint brought against the United Kingdom by Nautilus International, RMT, the TUC and a number of international trade union federations. And it arose out of the P&O Ferries scandal, which was mentioned earlier this evening. It will be recalled that there, at 7 a.m. on St Patrick's Day 2022, the employer summarily dismissed 786 seafarers, with security guards escorting them from the ships past waiting coachloads of agency staff from third world cheap labour countries recruited to replace them. Lords, I read from the report. The committee notes that the complainant's indication that while breaches of UK law entitle claims to be made in an employment tribunal, such claims are subject to statutorily fixed and very modest maxima. For this reason, the company was able to quantify with precision what the cost of the dismissals would be and to assess how long it would be before that cost could be recouped from future profits generated by the poverty wages and diminished terms and conditions of the new crews. The complainants thus alleged that the dismissal of 786 seafarers to replace them with non-unionised agency workers constitutes an act of anti-union discrimination. The complainants further allege that the existing legislation is insufficient to deter anti-union discrimination, as in practice employers can, on condition that they pay the compensation prescribed by the law for cases of unfair dismissal, dismiss any worker for being a trade union member with better terms and conditions under a collective agreement. The committee recalls in this respect that protection against acts of anti-union discrimination would appear to be inadequate if an employer can resort to subcontracting as a means of evading, in practice, the rights of freedom of association and collective bargaining. The committee considers that it would not appear that sufficient protection against acts of anti-union discrimination as set out in Convention number 98 is granted by legislation in cases where employers can, in practice, on condition that they pay the compensation prescribed by law for cases of unjustified dismissal, dismiss any worker if the true reason is the worker's trade union membership or activities. Committee recalls that the government must ensure an adequate and efficient system of protection against acts of anti-union discrimination, which should include sufficiently dissuasive sanctions and prompt means of redress, emphasising reinstatement as an effective means of redress. Furthermore, the compensation should be adequate, taking into account both the damage incurred and the need to prevent the repetition of such situations in the future. The committee therefore requests the government to ensure that an adequate and efficient system of protection against acts of anti-union discrimination, which should include sufficiently dissuasive sanctions and prompt means of redress, emphasising reinstatement as an effective means of redress. End of quote. But Lords, of course, there the committee considered that the collective dismissals were in order to avoid long-standing collective agreements which provided for notice of dismissal and consultation over proposed redundancies that they regarded as anti-union discrimination. That situation, of course, will not occur in every collective redundancy. Of course, that's the case. But it will be true in many, though not all, collective redundancy situations. And I should add that what we're looking at here is really bad employers. The remedy that I'm proposing will not be used against good employers that do their best to deal with the situation. Lords, the tribunal remedies which the committee considered very modest were not just for failure to consult over collective dismissal, but included compensation for unfair dismissal as well. Here we're considering the even more modest, statutorily capped compensation for failure to consult. As the committee held, what is needed is, quote, sufficiently dissuasive sanctions and prompt means of redress, emphasising reinstatement as an effective means of redress, unquote. Lords, only an injunction will achieve that outcome. That would have stopped P&O ferries in its tracks. I have to say to my noble friend, the Minister, that I can see no reason not to add this remedy to those available to restrain such unlawful activity. And whilst the increase in award from 90 to 180 days, or the maximum award, I should say, because the tribunal has to assess compensation as what is just and equitable up to that cap, is not sufficient in itself. Since injunctions are available for breach of contract, I ask, why not for breach of statute as well? I beg to move.